I'm Drew Stevenson, and this is a lecture about the Securities and Exchange Commission, or SEC v. Chenery, a U.S. Supreme Court case from 1947. This is actually the second time this case went up to the Supreme Court, so this is technically Chenery II. And this is about administrative agencies having discretion to use adjudication rather than rulemaking in announcing policy. This is actually for two of my classes, administrative law and statutory interpretation and regulation, because it's in the casebooks I use for both of those classes. In fact, this case is in almost every administrative law casebook. It's a very famous case that really should go in your kind of column of cases about deference to agency procedures, about rulemaking, and so forth. The downside of this case in your casebook is that the opinion itself, because this was the second time it went to the Supreme Court, doesn't really explain what's going on, what the facts are, what Chenery was trying to do, or why the statute involved was so controversial. So I'm going to try to give you a little bit of that background after I give you the main takeaway from this case. So our main takeaway here, just so you don't lose me, is that agencies can make what we'll call rules through case-by-case decision-making or adjudication, in addition to like the regular way of promulgating regulations or codes, as long as the agency is working within its enabling statute. And this is similar to, or at least analogous to, the way common law courts developed law sort of in an evolving way, incrementally on a case-by-case basis to generate precedent. So as you know, in the common law era, courts would take a case, and if it was a case of first impression, they would just have to decide what the rule is, often by analogizing to other type principles in the common law. Or if it was a new set of facts and they had to apply existing precedent, they would sometimes have to make decisions about how precedent should apply to a new set of facts. And that's what the SEC wanted to do here. They really liked the law. It was being run. It was a new agency, and some famous law professors have been recruited to launch the SEC, and they were trained in common law, and thought that that was a great way to have precedent made, especially at the beginning when they're still first getting started out, to sort of have it this evolutionary sort of common law incremental step. And so they wanted to announce their policies or rules that would then be the policy going forward on a case-by-case basis. And in this particular case, the SEC needed to decide whether to approve or reject a corporate reorganization and merger plan for a water company. A lot of shareholders had lost their investments in the stock market crash. And the SEC encountered sort of a novel problem here that I'm going to explain. And so they declared or announced what their policy was to address this type of situation as part of rejecting this reorganization proposal. And so this case, Chenery II, basically says agencies get to do this. So that's your big takeaway, is agencies, if they don't want to promulgate a regulation that's going to, following notice and comment rulemaking and so forth, they do have the latitude, probably under their statute, to just decide things on a case-by-case basis under Chenery II. So now let me give you the background. If you've played Monopoly as a kid and used a classic Monopoly board, you may remember that there were two properties on opposite sides of the board, Waterworks and the electric company, that are utilities, which were low rent ones to buy. So you didn't make a lot of money off of them. But if you owned both of them, it was to your advantage. And so sometimes people wanted to get both of the utility companies. Well, but these were there for a reason, put on in the Monopoly game, because this was a big problem in the 25 years that leading up to the 1929 stock market crash. Basically, we had these things called public utility holding companies, or PUCs, that owned most of the electric and water companies, which remember, back then in the early 20th century, these were pretty new. Cities were just getting electrified and just getting electrical lines run all through the city, and were putting in city water systems and sewer systems for the first time. So these were kind of new. And then these elaborate conglomerates were created that would own utility companies across state lines, and they would sometimes own the suppliers, and then the companies that bought a lot of and used a lot of the water and so forth. And they kind of had a pyramid structure to them. And by pyramid, I mean that there were some owners at the top who usually you couldn't figure out, because you'd have a holding company that owned other holding companies and so forth. But the people at the top made a lot more money than most individual investors. And so in fact, sometimes exponentially more money. And this meant that when the company when shares dropped in value, the people at the bottom of the pyramid lost a lot more of their value than the people at the top. And when the share price went up or profits went up, the people at the top made disproportionately more money than exponentially more than most of your like average middle class investors and people that had put their retirement savings into this. So in fact, these public utility holding companies were a major cause of the 1929 crash that triggered the Great Depression. And many of the main players with these pucks, the people at the top of the pyramid, declared bankruptcy or just fled the country. And people were mad. And in 1935, Congress passed the Public Utility Holding Company Act, a whole statute just about this problem, after a really fierce legislative battle. In fact, the stories go, this was actually the fiercest battle in Congress of any of the New Deal legislation, because this was very controversial and there were a lot of people who had a lot at stake. The act actually kind of matters for this case. And part of it is that it gave sweeping powers. Congress gave sweeping powers to the SEC, basically to dismantle these holding companies. Congress wanted the SEC to get rid of them and dissolve them. But it also the statute allowed the SEC to make exceptions in special cases. And so if there was a utility holding company that had a special story or a unique situation, they could propose an alternative reorganization plan and see if the SEC approved it instead of just dissolving. And here we meet the company at issue in this case, which was called the Federal Water Service Corp. And it had a controlling shareholder before the crash named Ostrom. Ostrom is actually the real villain in this case. He's not mentioned, but he's in the background, and he is kind of the bad guy that's the problem, not Chenery. Ostrom fled the country after using the bankrupt water company as fraudulent collateral for a large bank loan, a commercial loan, and from Chase Bank, and the loan went into default. In other words, it kind of seems like Ostrom took the money and ran. So the bank foreclosed on the company. It ends up as the unhappy receiver of a bankrupt company, and is looking to sell off the company or its assets to recoup some of its losses on this defaulted loan that Ostrom had taken out. And so Christopher Chenery enters the picture at this point, wanting to buy the indebted water company, the essentially defunct water company, from the bank, which had repossessed it. So he's not the villain in this case, even though he ends up having a falling out with the SEC and litigating against them. He was a wealthy individual who had invested in these pucks before the crash. There was no indication he had done really anything wrong. And he was thinking that he could buy the company and actually turn it around, reorganize it and make it profitable, and maybe even help some of the people who had lost their investments to recover their losses. By the way, Chenery and his heirs are famous for another reason. They're mostly remembered for owning and raising and breeding very famous thoroughbred racehorses. Some of the most famous racehorses that have ever lived in the United States and have won the Triple Crown and so forth were owned and raised by the Chenery family. And so that actually comes up in some of his negotiations with the SEC, that this whole thing with the water company was a side business. His real passion was the horse stables. And now Chenery started submitting reorganization plans to the SEC for the water company, and then the commissioners start negotiating about what they want this to look like. And now let's talk about that statute again. The SEC was authorized or supposed to approve a reorganization proposal if it would effectuate the purposes of the act and would be, quote, fair and equitable to the persons affected by the plan. That sounds pretty ambiguous, but a lot of New Deal legislation was. And in theory, they were supposed to kind of use formal adjudicative proceedings to approve the plan. And use like formal adjudication. Now, before you get confused, look at the date on this case. It predates the enactment of the Administrative Procedure Act. So the APA doesn't have any bearing here. It didn't exist yet. And probably the SEC was supposed to do this, but there's no rule that the SEC can't sort of negotiate with a party before this is going to happen, before they're going to make a final decision. And so that's what they did. They started kind of a back and forth. Well, maybe if you structured the deal this way, or we don't like this plan, please try again. And the SEC basically told Chenery it would not approve any plan unless the plan gave most of the stock in the new company to the holders of the preferred stock in the original company. And this was designed to thwart the abuses of the old puck schemes. Now, I don't want to confuse you too much or get too far off track, but basically the preferred stock shareholders, the stocks cost more, and then you got more in like monthly or annual dividends from the profits. But the bad guys in this who sort of really owned this would then own a controlling interest of the common shares. And so they would kind of dangle these preferred share stocks out there as a way of attracting investors, but who weren't aware that there was a single individual who, through a series of shell corporations and holding companies, really was able to pull the strings and control the company. Also, keep in mind that at this point, the SEC is a new agency, and this statute was new, and the alternative, this system of new proposals was also new, and not a lot of people were doing this. This was the exception, not the rule. And so all of that means that we didn't have a big body of case law. The courts hadn't really had a chance yet to interpret the Public Utility Holding Company Act because it was brand new. The SEC is kind of a new agency and doesn't have a lot of guidance, can't look to a lot of court decisions about its parameters or its authority. And the problem they're dealing with is kind of new. So the SEC is in uncharted territory here, and they wanted to start making policy on a case-by-case basis. Okay, so Chenery finally submitted a reorg proposal that seemed to meet the SEC's demands for how new shares would be allocated. So there had been some back and forth, and he's like, fine, here's a proposal, a way of structuring it that will give the preferred share stockholders more rights and so forth. But there was something else going on in the meantime. Chenery himself had become concerned that some anonymous figure using, again, like anonymous purchasers or holding other shell corporations was trying to do a hostile takeover, it seemed like buying up a lot of shares of common stock, because it was still being traded, even though the company was basically bankrupt. And it was weird that somebody was buying up shares rapidly in a company that wasn't making any profit. And so he thought that this was Ostrom, Ostrom through back channels was trying to regain control of the golden goose here, this company that had made him so wealthy. So Chenery decided to buy up shares to try to fend off this hostile takeover from who knows who, but maybe it was Ostrom himself. What Chenery did at the time was completely legal under state and federal laws, but it sort of looked like insider trading because he was personally involved in the negotiations with the SEC for the reorganization, and then is personally buying shares of stock in the company. So, well, he's privy to what's going on in these conversations with the SEC. And so even though this technically didn't violate the statute, it raised red flags for the SEC about how it looked. And so the SEC had an interesting counteroffer that they would approve an amended plan that would basically cash Chenery out for his stock and would eliminate the appearance of insider trading, which, remember, is also kind of a new thing at the time. And the SEC was relying on common law equitable principles and fiduciary duties and things like that, that would have said that managers shouldn't profit from trading on their own company shares at the expense of shareholders. And they thought that since this was taking place during negotiations about a reorg with the SEC, that those kind of common law fiduciary duties would say that Chenery should have clean hands in this situation. Remember, we haven't even gotten to a true formal adjudication of his plan. This is just kind of an informal counteroffer from the SEC. So the story goes from people that were at the meeting that Chenery kind of liked the counteroffer because he was still going to come away and recoup his investment and so forth. But his lawyer didn't like this. The lawyer exploded apparently, and because this looked like this new agency overreaching and being on a power trip. He announced, shouted, "That's unconstitutional." And so, in fairness to the lawyer, Chenery's transactions, his client's transactions, were fully legal under the existing laws. Chenery hadn't really done anything wrong. The SEC wasn't saying he had done anything fraudulent or wrong. He was very open about why he had bought these shares and what he was trying to do. And but the lawyer insisted on litigation. And then we get to the DC Circuit, and they actually agree because they were suspicious of what the SEC was doing. They thought the SEC was out of bounds, making demands on someone who hadn't technically done anything illegal. So this goes to the Supreme Court from the DC Circuit, and that's Chenery I in 1943. Note that this is not in the casebook that I use in my classes, but it is in some, Chenery I is in some administrative law casebooks. But I need to tell you just what you need to know to understand what happens in Chenery II. So the Supreme Court here decided in a 4-3 decision, they only had 7 people on this, that the SEC was wrong, but they remanded them to kind of have a do-over. Instead of reversing them, they just remand. Now, the holding of Chenery I, even though it's not in your casebook, is still basically the rule today. Judicial review of an agency action is limited to the stated basis on which the agency acted at the time. In other words, a court can't look at what the agency did and the outcome and substitute and say, well, you did it for the wrong reason, but here's a better reason, and we agree with the result. They do that with lower courts. So the appellate courts can take a lower court decision and say, so we agree with the outcome or the verdict in this case, who won, but we think you did it for the wrong reason, and the real rule is this. But the Supreme Court says that they don't want courts treating the agencies like that, nor do they want the agencies getting to kind of come up with a new rationale after litigation starts. In other words, they should have to decide whether the rationale that the agency was using at the time they made the decision before it was challenged was valid. And so in Chenery I, the SEC had basically relied on common law precedents about fiduciary duties and equity, and did what we teach first-year law students to do. They had analogized to other lines of precedent from property law and wills and trusts and estates. Why? Because this whole thing about reorganizing companies in this law was kind of a new area. They also invoked their own experience and expertise and basically said, based on our experience and expertise, we think this looks like insider trading and we want to avoid the appearance of that. But that didn't get a lot of traction because remember, this is a new agency. It is led by some really famous law professors, but they didn't have a long track record that the court could say, yes, yes, you've regulated this area for decades and people have relied on your decisions and so forth. So the court rejected all of these arguments, even though it actually agreed with the agency's intentions and conclusions. So the court here isn't mad at the SEC. They don't think the SEC is trying to do anything wrong, but they don't agree with how they're doing it and kind of give the idea, they remand the case and say, you need to redo your decision with a better reason than just doing what a judge would do. Stop pretending that you're a common law court and act like a regulatory agency. By the way, I pulled a quote out from Chenery I that isn't even in your casebook, but this is the sentence from Chenery I that starts getting quoted by later courts, including some cases that are in our course, like the Overton Park decision. So, quote, the Supreme Court established the proposition that when an agency gives the wrong reason for a decision of policy or law, a reviewing court will send the case back for reconsideration, even though the court might have upheld the order if a different reason had been assigned. This is a really important and somewhat counterintuitive point for students to understand, that the court can't accept either a post hoc rationalization that sounds plausible or its own better reason for doing something just because it agrees with what the agency did ultimately. They are supposed to, if it's the wrong reason, they have to send it back and the agency has to redo it with the right reason. So the Supreme Court vacated and remanded. And the SEC basically reached the same conclusion again. We reject this reorganization plan from Chenery because he's not cashing himself out. But this time it relied on another justification, which it actually tried to use in Chenery I as an alternative justification. And the court said, we're not going to do that because you didn't use this back when you were making the decision in the first place. You thought of this on your way to court. And so this was all based on the wording of the enabling statute, which said, remember that the SEC should do what's fair and equitable to the persons affected by the plan. Now, stop everything for a second. You've probably heard from a legal realist perspective, if we're going to be sort of just objective about this, this sounds like exactly what the SEC did in round one in Chenery I, except because we're talking about fairness and equity and fiduciary duties, except there they cited a whole bunch of common law court decisions and reasoned by analogy and all the stuff that you would have done maybe as a student on your first year law school exams in an essay question. And here they just found basically for a section of their statute that said the same thing and quoted that. And that works for the court. So the case goes back to the Supreme Court for another round. And this time in Chenery II, the 1947 case, the Supreme Court sided with the SEC and upheld this practice of rulemaking through adjudication. Really, why? Because the rule was based on the language of the enabling statute. Now, please note here that the personnel on the court had changed a little bit between 1943 and 1947. And so the court had two new members in Chenery II, and the majority from Chenery I are actually mad. They're the dissenters in Chenery II and vice versa. In other words, the two new members went the other way. And so as much as legal commentators or maybe even notes in your casebook may try to cast Chenery I and II as, well, the agency did the same thing for different reasons, and the second reason was okay. You could also just explain it as different people were on the court, and the people from Chenery I still would not have approved of what the SEC did here, the justices, but now they're outnumbered, they're outvoted, so they're in the dissent. And the dissenters from the first case who thought that the SEC should get deference are in the majority here, but are basically citing a different saying that have a reason that this is different. Now, later legal scholars saw the basic problem here as the SEC announcing a general rule or principle for the first time in its adjudication about this case. And as you would imagine, this raises obvious concerns about fair notice to prospective violators and the rule of law argument in Justice Jackson's dissent here. Now, remember that Justice Jackson, where was he in the between 1943 and 1947? Well, he had been sent to Germany to preside over the Nuremberg war trials. And one of the big criticisms, he came back from that sort of with a changed perspective. And now he's back on the court. You may read Justice Jackson opinions in some of your other courses, either as a majority opinion or a concurring or dissenting opinion. And he kind of has very similar themes every time he writes an opinion. He's very concerned about the abuse, the potential for tyranny from unchecked executive power, like had happened with the Nazis in Germany. And so basically the courts had decided to let Hitler do whatever he wanted and go along with it. And he saw what had happened, the horrors of what had happened. At the same time, Justice Jackson was subjected to a lot of media criticism, especially in Europe during the Nuremberg war trials like this was a new thing. He's talking about human rights violations and so forth, and that weren't actually a law that anybody had agreed to before World War II, and he's holding people to that. So he's a little self-conscious about that. And in this case, that he may be projecting a little bit of, because he had become self-conscious about sort of ex post facto or after the fact rulemaking through the Nuremberg war trials. He's worried that the SEC looks like it's doing the same thing. And he's also worried about the SEC as an executive agency overreaching. Now, the dissenters, again, in Chenery I became the majority in Chenery II, and they were focused on the efficiency concerns. We've got to let an agency do its job. They'll never be able to govern or do anything if the courts are meddling constantly and constantly harassing them and undoing everything they try to do. And so, and they also thought that if the courts required them always to promulgate ex ante regulations, that the agency wouldn't be able to deal with a new situation that came up, like in this case. So this case is important for holding that agencies may indeed devise rules and announce policy in the context of an adjudication, sort of like the common law courts would have done. So where does this leave us? Well, after Chenery, there were still some remaining questions about how far agencies could go in making major policy rules through adjudication rather than rulemaking. And the court mostly resolved this uncertainty in another case called Bell Airspace in 1974. And this is in some casebooks or in the notes in my administrative law casebook. Okay, that concludes our lecture about SEC versus Chenery Corp.